Do you have a copy of this? Do you want a copy for your records?
Yes.
Okay, you can have this one I took. It doesn't have any staples in it.
All right, Ms. Rivers, you ready? That was me. All right, all better. Let's get on the record in State versus Willie Williams. Mr. Williams, how you doing?
Fine.
Happy December.
Yes.
This is 21 SC 179174, and it is my understanding, Ms. Wood, that Mr. Williams is prepared to enter a plea. And it sounds like if everything goes smoothly, it will result in a referral to an entry into drug court.
Yes, Judge, that's correct.
Excellent. Mr. Williams, in a moment, Mr. Hand, the prosecutor who's seated at that table, is going to put you under oath. Once you're under oath, you'll need to answer all of his questions and mine truthfully and completely. I also need you to let Ms. Wood or me know if you've got any questions. If you can't hear what's being said or someone says something that is different from what you thought was going to happen, I need you to tell me that, okay? All right. Mr. Hand, when you're ready.
Yes, Judge, and I'll reposition myself before. Mr. Williams, can you please raise your right hand for me? Okay. Do you swear or affirm that the statements that you are about to give the court is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower it. Please state your true and correct name for me.
Willie Sean Wade.
And at this time, are you taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medicine that you would normally take that you have not taken or been given today?
No.
How old are you?
54.
I'm sorry?
54.
Okay. And how far have you gone in school?
12th grade.
Can you read, write, and understand the English language?
I can read a little bit
Okay. Do you understand
English.
proceedings orally
Yes.
right now?
Huh?
Do you understand what's happening right now?
Yes.
Okay.
You can speak English just fine, understand someone speaking English, but if I were to give you a complicated document, that might be more difficult.
Right.
Got it. I will not give you a complicated document.
Okay.
All right.
Mr. Williams, do you understand that you have been charged with the following offense, aggravated assault in indictment 20? I'm sorry. That number, grab it for the record, is indictment 21 SC 179174.
Yes.
Okay. And do you understand that you have the right to plead guilty or not guilty to that charge?
Yes.
Do you understand that if you plead not guilty, remain silent, or not enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes.
Okay. Have you had an opportunity to review all of your rights with your attorney?
Yes.
Do you need more time to speak with your lawyer about the indictment and the facts and circumstances around the charge?
No.
Are you satisfied with your lawyer's services?
Yes.
Okay. Sorry. Attorney Wood, do you waive a formal reading of the indictment for purposes of today's plea?
So waived.
And do you waive any and all defects of the indictment for purposes of today's plea as well?
So waived.
Judge just stays unaware of any unknown warrants related to this charge today.
Okay.
Mr. Williams, do you understand that the minimum and maximum sentence for the charge of aggravated assault to which you're pleading guilty today is 1 to 20 years in prison?
Yes.
Okay. And do you understand that you are entering a negotiated plea today, which means that the state will recommend the following sentence to the court? That is 5 years to serve 6 months, which will be reduced to time served. The balance of that will be probated with the condition of entering accountability court upon finding stable housing.
Right.
Do you understand that to be the agreement today?
Okay. Yes.
Do you understand that the court is not required to accept the state's recommended sentence today?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on the charge today?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea today, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, which is the recommendation today, that you cannot violate any criminal laws of any governmental unit, that being municipal, county, state, or federal?
Yes.
Do you understand that if you are placed on probation, you must follow all special conditions of your probation?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Additionally, do you understand that if you fail to follow all special conditions of your probation, that you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you must not receive, possess, or transport a firearm at all?
Yes.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, which include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea today?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of aggravated assault in the indictment today?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
Is this guilty plea, do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes.
Do you understand that for a felony charge, which is the charge today, you only have 4 years from today to file this document called a habeas corpus petition?
Yes. But let me get it off my record.
No.
No. I can explain, Judge, right much more.
No, you can go ahead and explain.
No, so
No.
to appeal today's conviction, if you believe that you want to challenge the voluntariness of this conviction, you file a document that's called a habeas corpus petition, which would normally be done by your counsel.
But two things. One, you don't have a right to a lawyer for a habeas matter. It's actually it's going to seem complicated. It's a civil proceeding. It's not a criminal proceeding. You're basically suing, saying, hey, judge took my plea, but I didn't really mean it. If you are comfortable with where things are going, you don't need to worry about this much. But sometimes 2-3 years down the road, defendant says, that I didn't mean for that to happen. My lawyer tricked me, or I didn't understand what was going on. Not happening here. And then you file this thing called the habeas. But the important point you understand is that you file it. You don't have a right to a lawyer. You could hire one, but if you can't afford one, you'd have to do it. And number two, you only have 4 years from today to file that. Now, if you're getting the sentence that's recommended, you'll be done with drug court and on probation. So I don't know why you'd file it when that 4-year mark hits, but you certainly have that right. I need to make sure you understand that right.
Yes.
Okay.
All right. And Judge, at this time, the state will give a factual basis for the plea.
All right.
Judge, if this were to proceed to trial, the state would show that approximately 7:30 p.m. on September 27th, 2020, MARTA police responded to a call of a person being threatened at Oakland City train station with a knife on board a train. The victims of that situation were 2 individuals, Carlos or Toto and his wife, Kelly Agudelo. They were identified that the defendant was stating that he approached them with a knife. I spoke to them for more clarity beyond what you can see in the warrants. They stated that he was asking folks on the train for money. At some point, he began insulting Ms. Agudelo, who's the wife of Mr. Hurtado. He felt like he was insulting her to get Mr. Hurtado to say something to him. And at some point, he pulled out a knife. That knife was never swung at Mr. Hurtado, but he felt like he was using it to intimidate him. He then left the train. He stated that MARTA police were nearby and they had someone who was conducting the train had seen what happened as well. And so that's why they were close by. They never called the MARTA police, but they did alert them that this guy was following them off the train and that he had a knife. Also, this was captured on surveillance footage at the MARTA station. What was captured was him shouting profanities at both of them through the doors upon exiting that train. This occurred, that train station is at 1400 Lee Street, which is in Fulton County. And that essentially makes up the factual basis, Judge. There was no further harm or injury to Mr. Hurtado. I did speak to him and his wife, and they both stated this happened a while ago. They want to move on. They do want him to get help, though, if this is fueled by alcoholism or some type of drug use.
Okay.
Nothing further.
What do you have about criminal history? We don't have anyone on the Zoom to help us with that.
Judge, I have a long history of 53 arrests.
Okay.
And I have at least 5 felonies that I was able to identify through the GCIC.
Okay.
The most recent one being 2017 for wolf obstruction.
All right. Nothing that gives you concern. There's not a child molestation or a rape in there.
No, Judge.
Okay. All right. Thank you, Mr. Hand. Ms. Wood.
Thank you, Judge. Mr. Williams is 53 years old. He is a lifelong resident of the metro area. He does have a high school education. I spoke with both him and his brother. They both have confirmed that he has struggled with alcohol for the past 20 or 30 years. He has indicated to me he's never actually gotten the help that he needs for it, and he realizes now's a great time to do that. So we are excited for this opportunity that drug court is going to give him to have another chance at straightening his life out, Judge. For the dates, I just want to put them on record. He served a total of 199 days for this case. He was in 27 days in 2020 from September 28th through October 24th under booking number 2011929. And then he's currently been in 172 days since June 13th of this year through the present under his current booking number. We would just ask that you accept the state's recommendation in this case.
Okay. Mr. Williams, have you ever received medication for any mental health issues, anxiety, depression, anything like that?
Oh, yes.
What kind of medicine? What did you get help for?
Oh, Respidol.
Okay. And what was that supposed to help with?
Having sleeping nightmare.
Okay. So the doctor said it was relating to you having trouble sleeping.
Yes.
Okay. Anything besides alcohol that you've struggled with? Any drugs you've struggled with?
No.
Just alcohol?
It's alcohol.
Okay.
And drugs.
And drugs?
Yeah.
Okay. What drugs?
Cocaine.
Which have you struggled with longer, alcohol or cocaine?
Cocaine.
Okay. Drug court can help with both those.
Yeah.
Would you use them together?
Yes.
All right. So, I'm one of the 2 drug court judges. So I may have already told you this, but there's a 50-50 chance you'll end up with me as your drug court judge. That's not good or bad. It's just a coincidence. And if you end up in my half of the drug court, I look forward to working with you. But it's not that because you're getting drug court, you'll be working with me. That'll be a flip of the coin. I get half and Judge Krause is the other judge. So you might end up with her. You understand that drug court is not optional, meaning it will be a condition of your probation.
What do you mean?
I didn't say that very well. You understand you're going to have to do drug court. Drug court is not something that, if you decide it's not fun, you can walk away from.
Okay.
You understand that?
Right.
Because physically you'll be able to walk away from drug court. It's not prison. If you 2 months into drug court, say, I quit and walk away, you're able to do that. But because it's part of your probation, then you may get arrested for having quit drug court. You understand?
Right.
That's what I want to make sure you get, that you are basically signing up saying, Judge, I'm going to do drug court. I'm going to take it seriously.
Yes.
Is that you?
Yes.
Okay. Well, we'll see how it goes.
Okay.
Anything you want to add?
I'm ready to go now.
Ready to go now. Won't be quite that fast, but it'll be soon. Mr. Williams, I find there's a factual basis for your plea. My guess is you were drunk or high or both that day on MARTA, and you actually didn't mean to hurt these folks, but they weren't doing what you wanted them to do, whether it was giving you some money or getting out of their way or who knows what. And you scared them, and they should have been scared. It may have been you weren't going to hurt anyone, but they didn't know that, and they didn't know you, and they didn't know what you were up to. So I'll accept your plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You've had a good chance to talk with Ms. Wood, and you understand what she's recommending, but ultimately you're deciding this is what you want to do. Is that right?
Yes.
Okay. And a knowing plea just means a plea that someone understands. You have any questions about anything we've talked about?
No.
No, I find you understand. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a small problem with probation, maybe you miss a meeting, something like that, you and probation will sort that out. But if it's a big problem, you get kicked out of drug court, you get arrested again, something like that, that comes back to me, and we'll work through what happens. Do you authorize my staff, Mr. Williams, to sign the indictment for you indicating your guilty plea?
Yes.
Ms. Wood
Yes, Judge.
and Mr. Hand?
Yes, Judge.
All right. Mr. Williams, I'm going to follow the recommendation. I may need to say it a little bit differently so that you don't get out before drug court starts. But I am sentencing you. So let me ask this question. Ms. Wood, do you think that if I were to sentence Mr. Williams to 6 years to serve 1 year, with that 1 year being reduced to time served upon entry into drug court, that would, number one, in my mind, most importantly, keep Mr. Williams at Rice Street until either next Wednesday or the Wednesday after, because that's when they pick you up for orientation. So it's real soon. It's just on a Wednesday. That would keep Mr. Williams in place until drug court came to get him, but would not mean that he has to spend 6 more months there.
Yes, Judge, I feel like we've done that before and didn't have issues with it.
I don't think so either. And I will amend his sentence if drug court says, oh, we can't get him. But I think that builds us that cushion. If I were to say 5 years to serve 6 months, first of all, he's already served 6 months, so he may just get released. And I don't want you in jail any longer than necessary, Mr. Williams, but I also don't want you hitting the streets straight off, because I'm not so sure you'll then come to drug court. I want you to start at drug court. In fact, you have to, because they'll get you housing. And that's the real important piece. We are able through drug court to provide stable housing for 3 months, sometimes a little bit more, while you get on your feet. And so that's why I'm going to propose imposing a sentence of 6 years to serve 1 year, with that 1 year reduced to time served upon entry into drug court. So you'll have 5 years probation. Special condition of probation is simply that you complete drug court. As long as you do well in drug court, then the rest of your probation is going to be easy stuff. Drug court usually takes about 2 years, but partway through, you're going to get a job and you'll be doing things that maybe you haven't done in a while that will help you stay clean. All right. Mr. Hand, any objection to that?
No, Judge.
All right. So that'll be the sentence of the court. I've already signed the order, but we'll get it e-filed today that orders you admitted into drug court. So you've already been accepted. Now it's just a question of drug court folks getting you housing, and then they'll actually come pick you up. Hope Hall is not far from the county jail. They'll pick you up, bring you to drug court for orientation. You're going to have an ankle monitor for the first month. You don't pay. Actually, nowadays, they're giving them a wristwatch. It's going to look like you've got a fancy Rolex, not quite a Rolex, but a wristwatch that's like an ankle monitor. And drug court pays for that. You don't have to pay for it. But that way, just in case you get a little jittery on us after a week and don't show up, it's easier to find you. But if everything's going well for a month, they pop that thing off and you're still in drug court, but you don't have that. Any questions about any of that?
I get that put on while I'm in jail?
Yep. Well, drug court will put it on you. When they come, folks from drug court, when they pick you up, they'll bring you over to Hope Hall, which is where you go to drug court, where you have your classes, where you can get lunch, and they'll put the, I don't know what they call it, electronic monitoring device, EMD, on you. Okay. And they'll help you with housing. Excellent. Ms. Nelson, you need anything else? She's trying to find the non-mute button. I'm going to assume she doesn't need anything else. So we are all set and we can go off the record. I do need both lawyers to stay put.
Number.
Nope, Ms. Nelson says she has everything.
Okay.
She's going to be the strong side.